have a short dictation, 15 minutes, and then we'll take up the.
Continue case from supplementary item one. Second
अच्छा,
appeal.
वो
They will
वाला
be
case.
seeking time.
आप टाइम लेंगे? हाँ हाँ, आप टाइम कितना टाइम चाहिए आपको?
2 weeks काफी है.
2 weeks. केस नंबर कौन सा? सीरियल नंबर?
626 का Nelson है.
626. Item 39.
ऐसे नंबर 626 of 2015 with IE number 11904 of 2025. Counsel for the parties are present. Counsel for the respondent prays for and is granted. Time till 18th September to file a response to the interlocutory application. Post this case on 22nd. मिस्टर ए.के. दास के कोई जूनियर हैं यहाँ पर? आज उनका पूरा पैच लगा हुआ था, हो जाता है.
नहीं बुला ले. From supplementary list item 1, second appeal 129 of 1982.
नाइनटीन 1928 की पार्टीशन की बात है, क्योंकि उनका प्लेंटिव का ये केस था कि 1928 में पार्टीशन हो गया था, एंड बिकॉज ऑफ दैट पार्टीशन ये खेमन महतो का सारा प्रॉपर्टी उसकी बेटी को जाएगा.
उनका ये
कहना पर दिस पर्टिकुलर पार्टीशन तो कुछ ऐसा तो हो नहीं पाया. नाउ व्हाट वी हैव टू सी इज एग्जिबिट 1 सीरीज से प्रूव हुआ. बट द फल्क्रम ऑफ द केसेस, अगर पार्टीशन हो गया रहता तो इट विल डिवॉल्व अपॉन द डॉटर. अगर पार्टीशन नहीं हुआ रहता तो इट विल गो टू और चूंकि 1951 में ननकू महतो का डेथ हो गया, therefore under such circumstances the court has said that 1956 के पहले डेथ हो गया था, the property already devolved upon others. This I could gather, थोड़ा सा confirm if it is this way. यही है ना सर? नहीं सर, 28 प्रूव नहीं हुआ. हम लोग तो अपने सीनियर से यही सीखे हैं कि फाइल परत दर परत खोलने से सॉल्व हो ही जाता है.
इसका जितना जल्दी साइड फाइल बना ले उतना ही बेहतर है. मैं तो 1-2 बार और कहीं आया कोर्ट में.
जो भी है अब इसको कर देना है. अच्छी बात है कि मतलब आप लोग का भी कोऑपरेशन है तो मैटर्स टेकअप हो जाता है. आपको तो हम जाने नहीं दिए, अब आप कहीं जा सकते हैं क्योंकि केस आपके फेवर में ही जाने वाला है.
तो हमका बिजली कनेक्शन वाला आया हुआ है आज फॉर लास्ट टाइम में चैम्बर वाला.
जाइए. आपके जूनियर है ना? आपके तो सीनियर लग रहे हैं. आप जूनियर हैं? सीनियर है. लिखिए टाइटल सूट नंबर 25 of 1978 was filed wherein the plaintiff claimed that one Baldev Mehto had 4 sons, namely Nanku Mehto, Bhairav Mehto, Kehar Mehto, and Heman Mehto. And he had Rayati title, the Rayati Jama in village Balhara, and he was in joint possession with his sons as member of joint Hindu undivided family. Baldev Mehto had inducted certain persons as Dad Rayat over certain portions of land and had also given in Rehan within bracket mortgage certain other portion of land. Baldev Mehto died, as per the plaint, Baldev Mehto died before survey, leaving behind his 4 sons who succeeded and came in possession of the land and were collecting rent from the Rayats. It was further case that soon after death of Baldev Mehto, his 4 sons disrupted their joint family, separated in mess and residence, and partitioned the land, excepting few plots which were kept in joint, and those lands in the hand of the Rayats came in separate possession of the lands which fell in their respective takhtas, and also they were collecting the rent from the Rayats and dividing the same according to their shares. It was their further case that the Rayati Jama of sons of Baldev Mehto was recorded under Khata number 17 in the name of his 4 sons, in defined equal shares, and separate takhtas of land in khas and exclusive possession of each was recorded in their respective kabjawada in the remarks column. And the land in the hand of the Rayats were shown as Samilat within bracket joint
Joint.
within bracket joint. It was the case that those lands were not divided amongst the 4 brothers at the time of partition. They were shown as Samila. The 4 brothers came in khas and exclusive possession of their respective land without any claim or interruption from one or other brothers. The property which were in possession of the Rayat / mortgage ultimately came in possession of the 4 brothers, it was the case of the further case of the plaintiff was that soon after survey, Nanku Heman and sons of Bhairav and Kheher in or about the year 1928 divided the Samilat plots which were in their khas cultivating possession for the sake of convenience without any partition by mix and bond in 4 shares and came in separate possession of their respective land. The separate land in possession of Nanku in similar plots were described in Schedule B of the Plaint, and Kabjawada plot of Nanku Mehto, which he had got by partition before survey, were described in Schedule A of the Plaint. It was their case that Nanku Mehto on 5/7/26 obtained Rayati settlement of 3 bighas (17 katthas) of Gair-Majurwa land with the permission of deed and landlord by virtue of registered patta and thereafter further settlement of 1.38 acres from the same landlord by way of unregistered patta dated 7/9/1943. The land of Gair-Majurwa khata were described in Schedule C of the Plaint. The case of the plaintiff was that Nanku Mehto had 2 sons, Rupan Mehto and Bigan Mehto, and they formed a joint Hindu undivided family. Semicolon. Rupan Mehto and his wife, predeceased Nanku Mehto, and died in quick succession in the year 1928, leaving only 2 daughters, Jashoda and Tekni, who were pro forma defendant number 8 and 9. It was their case that after death of Rupan Mehto, his father Nanku and his brother Bigan Mehto continued as member of joint Hindu undivided family and remained in possession of Schedule A to Schedule C property. By the rule of survivorship. The plaintiffs claimed that Nanku Mehto died in a state of jointness with his son in the year 1952. And left behind his only son Degan Mehto and 2 daughters. And consequently, Nanku Mehto succeeded by right of survivorship, being the sole surviving co-partner, and came in exclusive possession of Schedule A to C land of the Plaint. the pro forma dependent number two daughters लिखे ना, only son Degan Mehto and two daughters Bedni and Lakhia. The two daughters were dependent number pro forma dependent number 6. Bedni was pro forma dependent number 6 and Lakhia had died, leaving behind her only son Harku Mehto, who was pro forma dependent number 7. And thereafter Degan Mehto alone paid rent for Schedule B land and obtained rent receipts. And he has also been contributing his share of the land for Khata number 17. It was the case that upon vesting of zamindari, rent of Khata number 17 was being paid jointly by contribution of all the owners of Khata number 17. And the Karamcharis and the Panchayat Sevaks made a mess by accepting proportionate rent from one or the other co-owners and have been issuing rent receipt in proportion. Further case of the plaintiff was that Bhairav Mehto left behind two sons, Siva Mehto and Latil Mehto. Siva Mehto also left behind two sons, Heman and Mohan, and Heman was defendant number 5. Khehar left behind 4 sons, Naim, Pradhan, Tipan and PEN, who were defendant number 1 to 4. Tipan has had 3 sons, Tejo, Tilak and Chodu. It was their case that it was a specific case that Kheman died issueless as widower in the year 1931, and his interest in land of Khata number 17 in village Balhana was succeeded by his 3 brothers, namely Nanku, Khehar and Bhairo, and they came in possession accordingly by dividing the land of Kheman. Special attention has been drawn of this court with respect to paragraph number 17 of the plaint, which referred to execution of various deeds relating to Schedule A to C land. As per paragraph 15 of the plaint, it was asserted that after death of Deegan in the year 1968-69, the defendants started luring the daughters of Rupan Mehto that is pro forma defendant number 8 and 9, daughters of Rupan Mehto who were made pro forma defendant number 8 and 9 to execute sale deed in their favor. And they executed a formal deed with regard to undivided interest in the land described in Schedule A to C of the Plaint. In favor of the plaintiff, although they had no interest over the property, the two formal registered deeds with respect to undivided share is dated 17/6/1969, both in favor of plaintiff number 1 to 3. The plaintiff number 5 had kept plaintiff number 6, the husband of plaintiff number 3, as her Garjamai, and she thought it fit to transfer half the land described in Schedule A to C of the Plaint in the name of her daughters and son-in-law, and plaintiff number 1 to 4 to retain half for herself in her lifetime. The plaintiff number 5 executed a sale deed in respect of some of the lands of Khata number 17 and Khata number 1/2 and 1/23 in favor of the plaintiff number 3 to 6 on 28/5/1969 and put them in possession. Subsequently, on 9/8/1969, plaintiff number 5 executed another sale deed in respect of some portion of Schedule A to C land in favor of plaintiff number 2 to 4 and put them in possession, retaining some land for herself. Thus, it was claimed that the plaintiffs have joint title to the land of Schedule A to C described in the plaint, and they have been in peaceful possession with respect to the same. It was the further case that the defendants succeeded to bring in their clutches the pro forma defendant number 6 and 7, who got registered sale deed executed on 5/6/77 with respect to the land described in Schedule A to C, belonging at one time to Nanku Mehto and thereafter to Degan, his only son. It was asserted that such sale deed was without any authority and was sham and paper transaction without any consideration and was null and void and could not create any title in favor of defendant number 1 to 5 nor in favor of pro forma defendant number 6 and 7. The defendants, the plaintiffs in the relief sought adjudication that since Nanku died in a state of jointness with his son Degan, who succeeded him by right of survivorship in the year 1952, pro forma defendant number 6 and after her death pro forma defendant number 7 had no right, title or interest over the land possessed jointly by Nanku and Degan, and therefore the sale deed dated 5/7/77 executed by pro forma defendant number 6 to 7 in favor of defendant number 1 to 5 was a sham, illegal and void ab initio document. A further relief was prayed seeking a declaration that the plaintiffs are the owners of 1/3 share of the land owned and held by Khiman Mehto in Khata number 17 of village Balahara. The defendants filed their written statement and raised several objections, including objection regarding non-joinder of necessary parties with respect to the branch of Khehar Mehto and Bhairav Mehto, the objection was also raised in connection with requirement to pay ad valorem court fees. Apart from the aforesaid technical objections, it was a case of the defendant that in the survey settlement operation, the land under Khata number 17 was recorded as royalty right in the name of Nanku Mehto, Bhairav Mehto, Khehar Mehto and Khiman Mehto, and they were in possession of the same. And that the sons of Baldev Mehto were separated after death of Baldev Mehto. They were cultivating some land of Khata number 17 separately, and some land were in possession of Dar Rayat, and the land of Khata number 17 which were in possession of Nanku Mehto was recorded as Kabjawada of Nanku Mehto during last survey settlement operation. Similarly, the lands which were in possession of Bhairav was also recorded in the Kabjawada of Bhairav. and likewise the land which were in possession of Kheher and Keman were also recorded in the Kabjawada of Kheher and Keman during the last survey and settlement operation. Similarly, the land of the aforesaid Khata which were in possession of Dar Rayats were also recorded as Samilat of the said Rayats during the last survey settlement operation. It was the case that after the death of the Rayat, the land of Khata number 17 came in khas possession of the Rayats, and it was divided into 4 equal shares along with the Sammanit land. And was divided into 4 equal shares, although the Sammanit land was never partitioned by Mits and Bombay. And they began to cultivate the same as per their convenience. It was alleged that it was false to say that sons of Harrow divided the Samilit land in the year 1928. And it was asserted that the sons of Baldev it was also asserted that the sons of Baldev amicably divided the Samalit land in the year 1945. And not before, and each got 1/4 share with respect to plot number, with respect to Khata number 17. It was denied that the Schedule B property of the Plaint was allotted to the share of Nanku Mehto. It was asserted that Nanku Mehto got his share in the Samalit land, 1/4 in each and every plot of land. It was not correct on the part of the plaintiff to say that the entire area of Schedule B of the Plaint was allotted in the share of Nanku Mehto. Altogether, 101 plots were recorded at Samalit during survey. It was correct to say that Schedule A of the Plaint were the Kabja Badi land of Nanku Mehto, which he got from his brother in partition before the last survey and settlement operation. It was correct to say that the plaintiff, that Nanku Mehto acquired the land, an area of 3 biga 17 kattha of Gair Majurwa land from the then landlord. It was asserted that it was not correct to say that the plaintiffs obtained it was asserted that Nanku Mehto took Rayeti settlement of the state land on 5/7/1926 from the ex-landlord. And Nanku Mehto also acquired another piece and parcel of land, that is area of 1.30 acres under Khata number 1 of village Karamtan from the ex-landlord. It was asserted that it was not correct to say that Rupal Mehto died in the year 1928. Rather, he died in the month of December 1956, leaving behind his widow and 2 daughters, namely Jaswa, Devi and Tekni, who were the defendants in the suit. And Degan Mehto had died in the year 1954. So both the sons of Nanku Mehto died during the lifetime of their father. It was asserted that Nanku Mehto had died in the year 1957, leaving behind his 2 daughters, namely Lakshmi and Betni Devi. And the heirs of Degan Mehto and also the heirs of Rupal Mehto. It was the specific case of the defendants that Nanku Mehto died after passing of Hindu Succession Act, and the said 2 daughters of Nanku Mehto succeeded the right, title and interest and possession of their father. And they came in possession of half share of the property of Nanku Mehto, and the remaining half share went devolved upon the heirs of Degan Mehto and Rupal Mehto. Nanku got 2 sons and 2 daughters. Although the sons of Nanku died during the lifetime of their father, and accordingly Lakhia got 1/4 share and Begni got 1/4 share in the properties of Nanku Mehto. It was denied that Nanku and Degan came in possession of the entire area of the Schedule B land, and it was asserted that Nanku came in possession only to the extent of his share, that is over an area of 1/4 along with other Samilith lands. The story of survivorship as asserted by the plaintiff was denied. It was also denied that Nanku Mehto died in the year 1932, leaving behind his only son Degan. And it was false to say that Degan succeeded his father by right of survivorship as a sole surviving co-pastor and came in exclusive possession of the Schedule A to C land of the Plaint. It was their case that upon death of Nanku in the year 1957, his property devolved upon his daughters and heirs of Rupal and Degan by virtue of Hindu Succession Act and not by survivorship. And ultimately it was asserted that Begni Devi, daughter of Nanku Mehto and Sri Hattu Mehto, fell in need of money and they sold the interest of Khata number 17 with respect to the property which Nanku got settlement from ex-landlord. The sale deed was executed by two registered deed dated 5/5/1977 in favor of sons of Khehan Mehta for valuable consideration, and defendants also claimed that they were in exclusive possession openly, adversely and continuously, and they have also been paying rent with respect to the property. It was also asserted that Kheman Mehta died in the year 1957, leaving behind his only daughter Bhatni Devi, who succeeded her father and came in possession over the Kabjawada land of her father and also other lands, including the Sambandik land of Khata number 17, and she sold the same by registered sale deed dated 20/4/77, and the purchasers were in possession of such land. 77 का एक ही डीड चैलेंज किया था कि दोनों डीड चैलेंज?
एक ही डीड चैलेंज।
ये जो 20/4/77 का डीड है
वो चैलेंज नहीं हुआ।
वो चैलेंज नहीं है। The statements in paragraph 15 of the plaint were denied, and it was asserted that it was false to say that the daughter of Rupan Mehta had no right, title and interest over the land of Nanku. And it was also false to say that the sale deed which were executed by the daughters of Rupan were formal and sham sale deeds. The learned client court.
There
Official
are
written statement.
There are two written statements also. One by defendant number 6, 8 and 9.
Another written statement was
And-
filed by
and additional by the defendant. 1, 2,
all the defendants.
1, 2, yes.
A separate written statement was filed by defendant number 6, 8 and 9. Who stated that Kheman Mehto died issueless and widower in the year 1931, leaving behind his brother Nanku Kher and Heaven, who succeeded by right of succession and came in possession of the land of Khata number 17. It was also asserted that Nanku Mehto had died in the year 1952. And the defendant number 6 and her sister Lakhia did not succeed their father Nanku, who died in a state of jointness with his son Degan as a member of joint Hindu family. It was asserted that the sale deed dated 5/5/77 was sham and paper transaction and was void ab initio and without consideration. They supported it.
Yes.
यही तो एग्जीक्यूट किए हैं 8 and 9.
What?
8 and 9 ही तो एग्जीक्यूट किए.
8, 9 ही एक्सक्यूट किया.
वही सपोर्ट कर.
वही हम कहना चाह रहे थे, पेटनी एंड टेक्निक.
हाँ. Bethney and Technique, they supported that it was a sham transaction without consideration. Correct? And certain deeds of cancellation were also executed. उसका तो कोई मतलब नहीं.
There has not been made.
हाँ, that's right. It was asserted that Nanku Mehto did not die in 1957, but he died in 1952. And defendant number 6 and Lakhia did not inherit Nanku Mehto's property, nor did they get any share in his property. Kheman did not die in 1957, but he died in 1931 without any issue and a widower. Bhatni. And a widower. It was also asserted that Bhatni was not the daughter of Kheman, nor she succeeded Kheman. And that the sale deed executed by Bhatni in favor of Srimati Pokhni, Girija and others dated 24/77 is a sham and fraudulent deed. However, the sale deed dated 24/77 was not the subject matter of the suit. Correct? इसको last sentence को bold करते हैं. Additional written statement was also filed. by all the defendants. And it was stated that Keman Mehto died in the year 1957, leaving behind his only daughter Bhatni, who succeeded his property in Khata number 17. And she executed the registered city dated 24/77. It was stated that it was false to say on behalf of the plaintiff that Nanku Mehto died in the year 1952, rather he died in the year 1957. पार्टीशन के बारे में कुछ बोला नहीं है।
नहीं वो तो इसमें तो लगता है अमेंडमेंट के बाद आया
It was asserted that Nanku Mehto died after passing of the Hindu Succession Act, and therefore his daughters got right title and interest and possession over the property. Which Nanku had acquired from the ex-landlord White Patta dated 5/7/1926 and 7/9/1943. The learned trial court framed the following issues for consideration. And so far as the first substantial question of law is concerned, the same is primarily related to issue number 8 as to whether Schedule B plots were partitioned amongst the sons of Baldev Mehto as stated by the plaintiff in the pleadings in the year 1928. The learned trial court referred to the various exhibits, including Exhibit 1 CDs, in paragraph 31 of the judgment, and recorded that Exhibit 1 was ये Exhibit 1 से लेके series तक का page 23 से quote करना है. The learned trial court also referred to Exhibit 2 series which were relating to the rent receipts. और उसके बाद इसको quote करना है para 31 से. The issue number 4 and 7 were taken up together by the learned trial court. The learned trial court recorded that as per the records and according to the pleadings of the plaintiff, Nanku Mehto had two sons, Rupan and Degan Mehto. Rupan and Degan died before Nanku Mehto in a state of jointness in quick succession in or about the year 1928, leaving only two daughters, namely Jasto Devi and Takni Devi, within bracket pro forma depend number 8 and 9. And therefore, it was asserted that pro forma depend number 8 and 9 had no legal right. And according to the plaintiffs, after death of Rupan, his father Nanku and his brother Degan became the owner of the Schedule A to C property by rule of survivorship. And as per para 15, the plaintiffs viewing this situation got sale deed registered with respect to Schedule A to C property in their favor from depend number 8 and 9, the daughters of Rupan Mehta. The learned court specifically referred to the fact that plaintiff number 1 to 3 got two such sale deeds executed by depend number 8 and 9 on 17/6/69 with respect to Rupan's supposed undivided share, and by this very fact it was falsified that there was partition of Sammalit land amongst four sons of Baldev Mehta. The learned court specifically recorded a finding that there was no partition amongst the descendants of Baldev Mehta in the year 1928. The court further recorded that so far as the joint land of four brothers of Nanku in the year 1928, so far as joint land of four brothers of Nanku in the year 1928. The learned court also recorded that the descendants of all the members of the branch of Haro, Kheman and Kher were necessary parties, and the suit was defective for non-jointer of necessary parties. The point of limitation was decided in favor of the plaintiff. Which was covered by issue number 2. The issue number 7 was disposed of by observing that it has got not much importance. the issue number 5 in connection with Portrees was decided against the plaintiff. And the court was of the view that ad valorem fees was required to be paid. By deciding issue number 9, it was a main issue in the case. The learned court recorded that Nanku Mehto had died after 1956. So the sale deed executed by Begni Devi and Harku on 5/5/1977 in favor of victim number 1 to 5 was not illegal and void. The learned trial court considered the documentary evidences on record in paragraph 45 and dealt with each one of them. And by referring to each one of them, the court came to a conclusion that the Exhibit 1 series did not show that there was partition amongst the 4 sons of Baldev Mehta. The learned court thereafter observed that the most important point was the period of death of Nanku Mehta as to whether he died in the year 1952 or in the year 1957. And after having held that Nanku Mehta had died after 1956, ultimately held that the sale deed executed by his daughters, na? Yeah, Begni Devi and Harku Devi are his daughters?
Yes, daughter and daughter's son.
Daughter and daughter's son on 5/7/77 was not illegal and void. So far as the learned first appellate court is concerned,
Only one thing I would like to point out. Exhibit 2 series, the 8 rate receipts relates to only Schedule C land, not for A and B. That has been taken note by trial court at page 23 at the bottom. 6th or 7th line from bottom.
okay. ऊपर जहाँ पे लिखे हैं ना 23 को कोट में वहाँ पे लिखेंगे that it has been recorded by the learned trial court that all the rent receipts of Exhibit 2 series were of Moza, Karamtan, which was Schedule C of the Plaint, but the plaintiffs have not shown any rent receipt of Schedule A and B of the
Yes.
Plaint. So far as the learned first appellate court is concerned, 2 points for determination was framed in paragraph para 8. Altogether 5 points for determination was framed. That is prior to coming into force of the Hindu Succession Act of 1956. And consequently held that the sale deeds executed by Bedni Devi and Hattu Mehto in favor of defendant number 1 to 5, the sale deed dated 5/5/77 was sham, illegal, void, and also recorded that it was without any consideration. Without consideration का भी finding है.
नहीं फाइंडिंग है लेकिन क्लेम तो नहीं है अपने के ऊपर।
नहीं claim तो था कि without
फाइंडिंग
consideration.
हम देख रहे हैं।
Finding है. Finding है in favor of defendant are sham, illegal, and without consideration.
But my submission is
हाँ इसका submission कुछ नहीं
Yes.
हो सकता है सर.
para 28. It is there, consideration.
Without consideration का finding है.
But the thing which has not been sought for, उसका finding देना, और जो मांगा गया उसका दे देना।
In paragraph 28, which is quoted as amendment.
जो मांगा गया है, कि अमेंड करके रिलीफ मांगा गया है, उस पर कोई फाइंडिंग किसी का नहीं। और जो नहीं मांगा गया है, उस दे रहे हैं।
In light of the aforesaid discussion, the first substantial question of law is to be answered, and it has to be seen whether the documentary evidence with the packet Exhibit 1 series, which are several transactions between the parties, establish the factum of previous partition, and also shows as to whether such partition was acted upon. And if that be so, whether the suit seeking partition to the extent of 1/3 share of the property belonging to Kheman Mehto, could be barred by principle of estoppel, waiver, and acquiescence. And consequently, under section 52 and 116 of the Evidence Act. 52 and 116 क्या है सर? Evidence Act दीजिए. Section 52 and 116. Of the Evidence Act are quoted as under. एक estoppel से है, एक conduct से.
Wait, that is.
डीड में क्या है, सेपरेट पोजीशन की बात की गई है,
Yes.
लेकिन
Amicably.
एमिकेबल सेपरेट पोजीशन की बात
Yes.
की गई है, लेकिन पार्टीशन बाय नीड्स एंड बाउंड्री कहीं
नहीं,
पर
पार्टीशन कर
यही है ना सर, पार्टीशन तो नीड्स एंड बाउंड्री होता है ना.
नहीं, वैसा कोई नहीं बोला. नाप जोख के बंटवारा होने के बाद कोई नहीं.
The learned counsel for the appellant has placed before this court some of the has placed before this court the deeds covered under Exhibit 1 series. And during the course of arguments, it transpired that in some of the deeds it has been recorded that there was, क्या बोलेंगे, amicable separation.
Yes, amicable parties.
हाँ.
And they are in possession accordingly by convenience.
There was amicable partition for convenience, but no such recital has been pointed out in any of the Exhibit 1 series that there was ever any partition by meets and bounds. इस वर्ड का ध्यान रखिएगा जो लिखे हैं. By convenience. This court further finds that the Exhibit 1 series have been considered by the learned trial court and the trial court also came to a definite finding that there has been no partition in the year 1928. This court is of the considered view that even if the Exhibit 1 series are taken into consideration, which showed partition for convenience,
Immediately for convenience.
partition amicably for convenience, the same cannot be said to be a partition or joint family property in the eyes of law, unless the partition is done by meets and bounds. In such circumstances, this court is of the view that the factum of previous partition by meets and bounds was not proved, and therefore there is no question of the तो पार्टीशन होना चाहिए ना।
पार्टीशन अब होना चाहिए, मेरा वही कहना था। कोई रिलीफ जो मांग रहे थे अमेंड करके, वो रिलीफ तो इनको मिला नहीं किसी कोर्ट से, तो अब नए सिरे से पार्टीशन के लिए जब तक नहीं कर पाते, बट लॉर्डशिप ऑब्जर्वेशन इन रिगार्ड टू अमेंडेड रिलीफ इज रिक्वायर्ड, जैसा आपको दिख क्या कि जब रिलीफ अमेंड होके आ गया and both parties have thoroughly adduced their evidences, तो उस पर किसी कोर्ट का फाइंडिंग है नहीं, रिलीफ डबल है।
And therefore the partition could not be said to be barred by principles of estoppel, waiver and effusions. बस इतना ही बोल के छोड़ दें। क्या करेंगे बताइए?
नहीं, इतना ऑब्जर्वेशन रिलीफ जो अमेंड किए हैं डबल ए, उस पर दोनों में से कोई कोर्ट का फाइंडिंग नहीं है। He has asked for partition in खाता नंबर 17,
Yes.
1/3 और 1/3 डबल ए। नोट करें, नोट करें। By amending the relief, they are 1/3 share
1/3.
in Kata number 1. In Kata number 17 of Village Balhara. Not a single word has been whispered by both the courts.
Appellate court बोल रहा है कि they are entitled to the relief as plain.
बस उतने।
तो हम बस
इतना
इतना, therefore both the just a moment, therefore both the substantial question of law just a moment.
एक मिनट,
हाँ.
रिलीफ पार्टीशन का अगर अलाउ कर रहा था, तो he should have directed to
हम कुछ नहीं बोलेंगे सर।
prepare a preliminary
ये
decree.
जो है ना, मैं जो सबसे ज्यादा सेकेंड अपील में फेस कर रही हूँ, बहुत ही केयरफुली सब्सटेंशियल क्वेश्चन ऑफ लॉ ड्राफ्ट किए।
नहीं होता क्या है, हम बताते प्रैक्टिकली क्या होता है। उस समय तो ऑर्डर 41 में जब केस आया तो सुपरफिशियली आदमी एक आध पॉइंट देख लिया जहाँ पर लॉ फेवर कर रहा है, प्लेस करके और जजमेंट दिखा के बनवा लिया, लेकिन होता नहीं है। सब्सटेंशियल क्वेश्चन आप एडिशनल अलाउ करिए या नहीं?
नहीं ऐसा नहीं है, लेकिन उसके लिए आप शुरू में ही पिटीशन फाइल करना पड़ेगा। ऐसे बीच में बोलने से नहीं होगा,
नहीं,
बिकॉज
जैसे
एडिशनल सब्सटैंशियल क्वेश्चन ऑफ लॉ के लिए
बिगनिंग में अगर बोलते भी हैं
नहीं तो आप पिटीशन फाइल करेंगे तो अदर साइड को सुन के तो हम जरूर डिसाइड करेंगे,
वो तो है,
लेकिन बिना पिटीशन के ऐसे फ्री स्टाइल में तो नहीं कर सकते।
हाँ, इन कोर्स ऑफ आर्गुमेंट अगर फॉर्मुलेट करते हैं तब मुश्किल है।
हाँ, तो वो अलग बात है ना, लेकिन उस तरह से तो नहीं होता है। तो हम आप सोच नहीं सकते एक सेकेंड अपील में आई डिसाइडेड सब्सटैंशियल क्वेश्चन ऑफ लॉ इन फेवर ऑफ द अपीलेंट, बट देयर वाज कॉन्करेंट फाइंडिंग ऑन लिमिटेशन, एंड देन आई टू से दैट आई कांट गिव यू एनी रिलीफ।
देखो तो हो सकता है बाद में फाइनल जजमेंट के समय में तो डिफर कर सकते हैं।
हम सिर्फ इतना ही बोल देते हैं, both the substantial question of law having been decided against the appellant, this appeal is dismissed. और हम कुछ नहीं बोलेंगे इसका।
ठीक है, as well.
अब वो लोग जाने कि कैसे वो लोग अपना चलेंगे, we just can't do anything about it. लेकिन पार्टीशन नहीं हुआ है ये बात तो तय है। That's it. ठीक है, यही लिखते हैं। बाप रे, सब रिकॉर्ड देख के तो मेरा एकदम
एक पेपर चाहते थे आइटम नंबर 21 में
हाँ।
एडजस्ट कर देंगे छुट्टी के बाद रखते हैं।
अभी कहाँ
ऑर्डर 41 में पहला
नहीं, ऑर्डर 41 अभी हो ही नहीं पाएगा, 4 बजने वाला।
इन पर हमरा प्रेयर करना था इसलिए कि हम आउट हो जाएंगे तो
नहीं हाँ, ऐसा बात नहीं है सर, इस तरह से नहीं करते हम, इस
नहीं,
तरह
ऐसा
से कोई भी
मिस्टर-
केस इस तरह से।
मिस्टर साहनी का पेपर है,
अच्छा,
इसलिए हमको प्रेयर करना पड़ा।
कोई बात नहीं। कौन सा मैटर है?
21
नहीं, आज टेकअप नहीं होगा सर,
ठीक,
आज टेकअप नहीं होगा। ये लीजिए। ये सबको भाई ठीक से रख लीजिएगा सब कागज सब।
जी। जी।
हाँ, जजमेंट।
Notified case under heading for judgment, item 1, second appeal, 118 of 2019.
This appeal is dismissed.
Fifth case, under heading for orders to discharge, item 5, FA filing number 5636 of 2025.
आप लोगों को कुछ मिला है?
एक और
कौन सा जजमेंट? आपको कुछ मिला है? दोनों?
हाईकोर्ट का है, डिवीजन बेंच है।
फुल बेंच कौन सा है आपका?
अच्छा अपना प्रोसीजर तो ठीक है, तो हम भी कह रहे हैं 12 तो मेरे ही पे
कौन से जजमेंट का पैरा 12 वाला?
मतलब पारा 12 जो है हिमाचल प्रदेश हाईकोर्ट का 1977 एससीसी ऑनलाइन एचपी,
ये कौन से एक्ट से है पहले तो ये देखिए।
ये लैंड एक्विजिशन एक्ट का दोनों जजमेंट दिए।
नहीं, एक तीसरा तो 1956 एक्ट से है, फर्स्ट अपील आंध्र प्रदेश,
वो तो हम दिए थे
जो भी दिए हैं
जी।
इसका है।
ये पहला वाला देखेंगे इनका वाला 77 सुप्रीम कोर्ट एससीसी ऑनलाइन एचपी, आंध्र प्रदेश वाला हम दिए हैं जो है
आंध्र प्रदेश वाला।
आंध्र प्रदेश वाला जी। आंध्र प्रदेश वाला में बेसिकली मतलब जो इंटरप्ले है सेक्शन 11, सेक्शन 23, सेक्शन 26 व्हाट शैल बी एन अवार्ड को डील कर रहा है, और सेक्शन 54 कहाँ अप्लाई होगा ये इसमें डील होके आए। मतलब इनफैक्ट हो क्या रहा है, लैंड एक्विजिशन एक्ट में अगर देखेंगे तो सेक्शन 11 में अवार्ड डिटर्मिनेशन होगा, डिटर्मिनेशन ऑफ द अमाउंट होगा। सेक्शन 23 और 26 जो है, जो कंपोनेंट्स ऑफ अवार्ड क्या होगा और फॉर्म ऑफ अवार्ड क्या होगा वो बता रहा है। प्लस सेक्शन 18 जो है वो कहता है कि इफ अवार्ड इज नॉट एक्सेप्टेड बाय ए पर्सन एंड a person is claiming further amount enhancement, फर्दर वहां पे भी ये बात आ रहा है कि अगर इंटर से पार्टीज के बिटवीन डिस्ट्रीब्यूशन की बात आएगी तो वो भी इशू 18 में कवर होगा।
18 में नहीं, 30 में।
30 में अलग से है, उसमें भी एक लाइन है लास्ट में
18 में नहीं जाता है।
एक
18 में 18 इज ओनली फॉर क्वांटम
क्वांटम नहीं इसमें
एंड 30 इज फॉर डिस्ट्रीब्यूट।
करेक्ट, लेकिन नहीं इसमें अपोर्शनमेंट ऑफ कंपनसेशन अमंग पर्सन इंटरेस्टेड सेक्शन 18 का लाइन में बोला, सो सेक्शन 18 के लास्ट लाइन में लिख दे रहा है। बट
देखिए, अगर मान लीजिए कई लोग हैं और सबको कॉम्पनसेशन मिला है
यस
और 5 में से एक ही आदमी एग्रीड है कि भाई हमको 10 रुपए नहीं हमको 15 रुपए चाहिए,
करेक्ट
तो वो भी जा
वो
सकता है।
आएगा
ठीक है, दैट इज ऑन द क्वांटम ऑफ कॉम्पनसेशन।
यस
30 इज फिक्स हो गया 100 रुपया, हमको 10 रुपए चाहिए, हमको 5 रुपए चाहिए, उसको मिलेगा इसको नहीं मिलेगा, जो
Correct.
आपका केस है।
करेक्ट। तो अब हुजूर सेक्शन 30 जो है वहाँ अपील नहीं लाई करेगी 54 की, वहाँ पे रेफरेंस होगा, वहाँ भी सेक्शन 30 में भी रेफरेंस होगा, परंतु वो वाला रेफरेंस आएगा सेक्शन 96 में यहाँ पर
हाँ ठीक है, वो आएगा ही।
ये आएगा यहाँ पे जो
उसमें तो सब में एड वैलोरम कोर्ट फीस
होता है मतलब वहाँ पे, लेकिन हमारा ये कहना है कि ये एक जजमेंट अभी दिए जो 77 एससीसी ऑनलाइन एचपी
नहीं, उनकी तरफ से मत, आप अपना बहस करिए।
नहीं
वो
हम
जो
अपना
judgment
ही
है, वो
बात नहीं बात कर रहे। यस्टरडे आई गिव ए जजमेंट मनोज, जहाँ पे आपको मद्रास हाईकोर्ट वाला दिखाए थे, उसमें यही कहा कि द रेफरेंस द डिसीजन इन रेफरेंस अंडर 3H विल बी इन द नेचर ऑफ ए डिक्लेरेशन, और जो जजमेंट भी है वो डिक्लेरेशन के ही फॉर्म में है। तो मेरा यही कहना है कि चूंकि ये डिक्लेरेशन है इसलिए फिक्स्ड कोर्ट फी लगेगा, एड वैलोरम नहीं लगेगा। पारा 12 वही सॉरी हम नोट्स ऑफ आर्गुमेंट बना दिए हजूर के कन्वीनियंस के लिए जो हम बात किए वो नोट्स ऑफ आर्गुमेंट बना दिए, जो जीस्ट है वो दोनों जजमेंट का।
या आईए नंबर कौन सा है आपका?
मेरा आइए एक नंबर बताइए। एक चीज खाली ऐड कर दे जो उसके अलावे
745 ऑफ
7459 of
2025 seeking that you are to pay only fixed court fees under award.
मतलब एक 77 SCCO लाइन HP देखा जाए फॉर मोमेंट। इसका पारा 12 देखिए जो एग्जैक्टली वही है। मोरओवर when a court decides a reference either under section 18 or under section 30 of the Land Acquisition Act, it does not give any declaration. Its function is limited and is confined to the fixation of quantum of compensation and to the apportionment of the same amongst rival claimants. If while discharging this function, the court is called upon to decide some incidental questions such as legal status of the contesting party, the said decision is obviously for achieving the main purpose of fixing the quantum and apportioning the same. Therefore, a decision on such incidental questions cannot convert the nature of the proceeding. It is therefore not correct to say the reference under section 30 of the Land Acquisition Act partakes the character of a declaratory suit simply because the court has to make an incidental inquiry about the legal status of rival claimant. यहाँ पे सिंगल बेंच हिमाचल प्रदेश डिवीजन बेंच ने ये बोला और एक सेकंड के लिए खाली बोलो यहाँ पे जजमेंट पे आ जाए प्यून जजमेंट जस्ट टू शो योर लॉर्डशिप द नेचर पेज नंबर पेज नंबर 94 एक बार देखा पेज नंबर 94 में 48 में इश्यूज 1 2 3 डिसाइड किए 49 इशू नंबर 4 whether the first party applicant आचार सरतामंद और सेकेंड पार्टी अपोजिट पार्टी आनंद माला so and so is entitled to get compensation amount of ₹4 crore so and so बोला 5 Roman 5 देखते हैं to what other relief parties are entitled for while decision of the main issues being issue number 1 2 3 this court already arrived at a conclusion that the applicant is not the owner of the acquired land and is not his self-acquired property. Above property belong to Anand Marg Pracharak Sangh. Therefore, Anand Marg Pracharak Sangh is entitled to get compensation amount 4 crore so and so for acquisition of land area so and so for purpose of so and so pariyojana in LA case number 31 of so and so award number 28 dated 13/2/23. So कह रहे हैं कि वही अवार्ड इनको मिल जाएगा. So there is no, मतलब it is a declaration as per me and section 30 के रेफरेंस में जो कुछ भी कहा गया है हिमाचल प्रदेश में मतलब 3G जो है वो रेफरेंस इसलिए है क्योंकि मतलब 3G में डिक्लेरेशन अवार्ड का हो गया 3H में वो अमाउंट डिपॉजिट हो गया अवार्ड जो बना और फाइनली रेफरेंस गया और रेफरेंस में डिक्लेरेशन हुआ कि इट विल नॉट बी मतलब पेड टू मी रादर इट शैल बी पेड टू द प्राइवेट. इतना ही कहना.
आपका डिक्री कहाँ है?
जी डिक्री में भी सेम लैंग्वेज डिक्री है नहीं दोनों में है मतलब एक ये है मतलब सप्लीमेंट्री एफिडेविट का मतलब पेज नंबर लास्ट छोटा सा सप्लीमेंट्री आइए जो है उसमें भी लगा हुआ है IA का पेज 14 में है और सप्लीमेंट्री एफिडेविट में भी लगा हुआ है। सप्लीमेंट्री एफिडेविट का पेज 5 में, सप्लीमेंट्री एफिडेविट का पेज 5 में बॉटम में सेम वर्डिंग। Lordship got that. यहाँ पे बोलता है it is hereby ordered that applicant so and so case is hereby dismissed. The applicant so and so is not entitled to receive the compensation amount by the award number 23 passed in land acquisition case number इतना. It is hereby ordered to pay compensation amount इतना of award number इतना इतना in the account of Anand Mark Pacharaks. यही पे इतना ही. To sum up, what I am trying to say, I am trying to say that the scheme of Land Acquisition Act and the National Highway Act is slightly different. There, Section 54 is a provision of appeal, and Section 30, Section 18, and 11, Section 23 में फॉर्म है, Section 26 में फॉर्म ऑफ अवार्ड है, Section 3 में ingredients of award है. Therefore, nature is bit different.
No, how is it different for the purposes of this? How is Section 30 different from this Section 3G4, 3H4?
Section 30 में भी अपील 54 का नहीं, Section 54 का अपील नहीं.
Section 3H4 is equivalent to Section 30.
कहा जा सकता है क्योंकि 96 में
almost वही है.
So 96 में वो भी आएगा, ये भी 96 में ही आएगा.
96 में ही आएगा.
दोनों आएगा 96 में. Section
आपका
96.
कहना है कि since it is only seeking a declaration,
It is only a declaration because it is not executable. And what is a decree मतलब एक चीज खाली में लिखा है डिक्लेरेटरी डिक्री क्या है. स्पेसिफिक रिलीफ एक्ट में सेक्शन 34 एक बार देखें. स्पेसिफिक चैप्टर 6 एक बार लीजिए ना, ये दे दीजिए. हमें दे रहा है हजूर करने को. यहाँ पे कोर्ट भी किया वैसा. Declaratory decree where no consequential relief is paid. Direction and discretion of court as to declaration of status of right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny is title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further. तो यही हो रहा है वो जो वहाँ रेफरेंस किया, और यही इसी नेचर का डिक्री हमको जजमेंट में भी यही वर्डिंग है. दिस
I'll please two judgments. Himachal Pradesh, your lordship has seen para 12. I'll read para 12 and then para 13. Moreover, when a court decides a reference under section 18 or under section 30 of the Land Acquisition Act, it does not give any declaration. Its function is limited and is confined to the fixation of the quantum of compensation and to the apportionment of the same among the rival claimants. If by discharging this function, this court is called upon to decide some incidental questions, such as the legal status of the contesting parties, the said decision is obviously for achieving the main purpose of fixing the quantum and apportioning the same. Therefore, a decision on such incidental questions cannot convert the nature of the proceeding. It is therefore not correct to say that reference to the section 30 of the Land Acquisition Act partakes the character of a declaratory suit simply because the court has to make an incidental inquiry about the legal status of the liable claimants. Now para 13. On the previous day, it rightly felt from the lawsuit, my lord, since in order to decide the claim, the right title and interest has to be decided, so it's a regular suit. We find that the exact point has been dealt with by the various high courts in India. The earliest decision on this point is found in the Calcutta case, R.E. Anandalal Chakrabarti, AIR such and such, wherein ranking chief justice has observed that Section 8 of the Court Fee Act deals with the amount of fee payable, makes a comparison between two things, the amount awarded and the amount claimed by the applicant. He has further observed that it appears to be reasonably clear that the comparison can only be between the amount awarded to the applicant and the amount claimed by the applicant. And there can be no comparison between the amount awarded to a number of persons and the amount claimed by one individual, representing his individual interest. Rankin has further observed in his decision that where the applicants have been given nothing by way of compensation and they claim a substantial sum, the amount of court fee is to be computed according to the amount of the claim. Ultimately, it was held that in such cases, court fees are required to be paid under Schedule 1, Article 1 of the Court Fee Act, read with Section 8 thereof.
That's it. Output full.
In this case, it has been held that ad valorem court fee will be paid, will be payable.
Full bench.
Full bench, just yes. I'll place para 13 and 14 of the same. This also arises of land acquisition where a reference was made. From the above discussion, it is now clear that reference court is a principal civil court of original jurisdiction, and the legislature has thus made a clear distinction between a tribunal and a court. The secondly, the application of reference made by a claimant and on which reference is made by the collector is in the nature of a plaint and the characteristics of a suit, which is yet another important ingredient of a decree. Thirdly, the award made by the civil court is of formal and final adjudication, which is deemed to be a decree, and the statement of the grounds of award, a judgment within the meaning of Section 2.2 and Section 2.9 of the Code respectively. Thus, all the essential conditions of a decree are manifestly present in the award as laid down by the lordships of the Supreme Court in the case of Diwan brothers. A corollary to the aforesaid discussion, the question arises that if the award of the civil court made in land acquisition cases is a decree within the meaning of Section 2.2 of the Code, whether the court fee payable on the memorandum of appeal against such award would be one as prescribed under Article 1A of the Schedule 1, that is ad valorem fee, or fixed court fee as prescribed under Article 11 of Schedule 2 of the Court Fee Act as claimed by the respondent. Already referred to Article 11 of the Schedule 2 of the Act will be produced here. I am not reading it. Article 11 itself eloquently speaks about its applicability. It applies when the appeal is not from a decree or an order having the force of decree. As held by the Supreme Court in Diwan brothers, in order to attract applications of Article 11, the following conditions must be fulfilled. There are 3 conditions. That the document sought to be stamped must be a memorandum of appeal, that the appeal should be presented to the High Court, and that the appeal should not be from a decree or an order having the force of a decree. The third condition of article is couched in a negative form, implying that this provision would have no application to appeals against decrees. But we have found that the award made by the civil court partakes the character of a decree under the deeming provisions of Section 2 of Section 26 of the LA Act. Consequently, Article 11 of Schedule 2 is not attracted at all and has no application to appeals against an award made by civil court. It is Article 1A of Schedule 1 of the Court Fee Act, which is attracted, and therefore ad valorem court fee is eligible on the memorandum of appeal against the award. Now, what is a decree? I may not point it out, but let me read it, my lord.
You are reading from where?
CPC, decree. Section 2.
CPC.
Section 2, subsection 2. Section 2, decree means the formal expression of an adjudication which, so far as regards the court expressing it conclusively determines the rights of the parties with regard to all of them, all the matters in controversy in the suit, and may be either preliminary or final. So here also another claim of all the parties have to be. It shall be deemed to include the rejection of a plaint and the determination of any question within section 144, but shall not include. That was the point. So in this case also, my lord, since the claim has to be decided, the plaintiff will have to pay. Appellant will have to pay the ad valorem court fee.
And this, in the Andhra Pradesh judgment, it has been held that it is a decree. Right? It has been held that order under National Highway also, if any adjudication is made by the court,
Yes,
it's a decree.
But it is a decree, my lord.
Okay. Only one line reply. This judgment was full bench. Was a reference under section 18 and appeal under section 54. मतलब एक लॉर्डशिप सीज मतलब फर्दर पैराग्राफ जो है para 15 of the same very judgment. The view we have taken about further extended by the provisions contained in 54 of the Land Acquisition Act, we provide that subject to provisions of the code, so and so, so and so. Now, first page itself, lordship will find head note जो है, this was a मतलब reference under section 18. Section 18 का वर्ड सेक्शन 18 एक बार देख लीजिए वर्डिंग, इसीलिए हम सेक्शन 23, 26 नहीं बोले थे, सेक्शन 18 देखा। तो सेक्शन 54 का अपील है, सेक्शन 30 का रेफरेंस नहीं, रेफरेंस टू कोर्ट सेक्शन 18 एक बार देखा जाए लैंड एक्विजिशन एक्ट का। सॉरी,
यहाँ पे तो आप अपील अंडर सीपीसी फाइल किए हैं।
हाँ सेक्शन 96
96
बिकॉज मतलब
और उसमें जो अपील सेक्शन 54 में फाइल
हाँ यहाँ क्वारल नहीं है थोड़ा भी कि इट इज नॉट ए डिक्री, इट इज इन द नेचर ऑफ ए डिक्री इटसेल्फ, देन ओनली मतलब वी हैव टू कम टेकिंग रेस्क्यू अंडर मतलब सेक्शन 96. So there is no quarrel, it is not a decree from cabinet, but it is a declaratory decree, therefore fixed court fee लगेगा। एड वलोरम कोर्ट फी के लिए अगर अवार्ड सेक्शन 8 का एप्लीकेशन कब होगा, मतलब सेक्शन 8 अगर कोर्ट फी एक्ट देखेंगे, एक बार खाली मेरे लिए देखा जाए कोर्ट फी एक्ट का सेक्शन किताब सेक्शन 8 एक बार देखें कि कहाँ लगेगा। सेक्शन 8 का रेफरेंस ले रहा है फुल कोर्ट, सेक्शन 8 एक बार देख लीजिए, सेक्शन 8 कोर्ट फी एक्ट सेक्शन 8 कहता है ना ये देते
ठीक है यहाँ पे तो
हाँ है। सेक्शन 8 कहता है फी ऑन मेमोरेंडम ऑफ अपील अगेंस्ट ऑर्डर रिलेटिंग टू कंपल्सन। The amount of fee payable under this act on a memorandum of appeal against an order relating to compensation under any act for the time being in force for the acquisition of land for public purpose shall be computed according to difference between the amount awarded and the amount claimed by them. तो मेरा यही कहना है कि सेक्शन 8 जो है यहाँ पे इसलिए नहीं आएगा क्योंकि सेक्शन 8 में अवार्ड की बात हो रही है और सेक्शन 8 विज़ावी मतलब सेक्शन 8 जब आएगा तो शेड्यूल में जाएगा ही नहीं, ना शेड्यूल 1 में जाएगा ना शेड्यूल 2 में जाएगा। सेक्शन 8 में आने के लिए देखना होगा कि सेक्शन वहाँ पे सेक्शन 11 यहाँ पे अवार्ड इज फाइनलाइज अंडर 3G। सो एक बार अवार्ड फाइनल हो चुका है, सो देयर इज नो क्वारल अपॉन द अमाउंट ऑफ द अवार्ड, खाली मिलेगा किसको, इशू यही है। वहां पे इक्वेट अगर 30 से करेंगे दैट्स सॉरी
for the learned counsel appearing on behalf of the parties on IA number 7459 of 2025. Wherein a prayer has been made for ignoring the defect regarding deficit court fees as pointed out by the stamp reporter by reporting dated 17/6/2025. The stamp reporter has reported that the court fees paid is short by rupees 2,99,010 as the ad valorem court fees is to be paid in this case. The learned counsel for the appellant has submitted that the LA case number 1 of 2024, in which the impugned judgment has been passed and the decree has been prepared, and the decree has been prepared, was instituted under reference by virtue of section 3H within bracket 4 of the National Highway Act 1956, seeking apportionment of the awarded amount, which was already determined in an award prepared under the aforesaid Act. The learned counsel submits that the applicant had simply sought a declaratory relief in connection with the compensation, and the compensation was already determined and adjudicated, and there was no dispute with regard to quantum of compensation.
We have not got. There was a reference.
Applicant. The learned counsel submits that the reference was decided in favor of the applicant, and the appellant is the awardee under the award prepared under the provisions of National Highway Act of 1956, and the impugned judgment is under challenge. He submits that since the quantum of compensation is not in dispute, and it is the entitlement of or apportionment of the awarded amount which is subject matter of consideration in the reference case, therefore fixed court fees which is applicable for seeking a declaration is payable. The learned counsel has referred to the provisions of the Court Fees Act as applicable in the state of Jharkhand, published by Jharkhand Gazette Extraordinary dated 24th of November 2023, and he has referred to column 13 thereof to submit that in order to obtain declaratory decree where no consequential relief is paid, the fixed court fees of rupees 1,000 is paid. The learned counsel has relied upon the judgment passed by Honorable Madras High Court in the judgment reported in 2024 SCC Online Madras 4369 within bracket Ramchandrian versus Saravan, and as referred to paragraph 7 thereof to submit that in a suit seeking a declaration in connection with compensation, fixed court fees is payable and not ad valorem court fees. Paragraph 5 and 7. The Learned Council has also relied upon, ये हिमाचल प्रदेश आपकी तरफ से लिखते हैं?
आंध्र प्रदेश वाला मेरा
अच्छा, the Learned Council has also relied upon the judgment passed by Honorable Andhra Pradesh High Court, passed in FA number 8 of 2025, decided on 10/4/2025, and has submitted that the law is well settled that it has been held therein that a judgment passed on a reference made under section 3H4 is a decree within the meaning of section 2(2) of CPC, and has submitted that consequently the appeal in the present case has been filed by invoking section 96 of the CPC. The Learned Council, appearing on behalf of the respondents, on the other hand, respondent state, on the other hand, has opposed the prayer and has submitted that ad valorem court fees is payable. He has referred to the judgment passed by Honorable Himachal Pradesh High Court, reported in 1977 SCC online HP 39, equivalent to AIR 1978 HP 51, and has submitted that it has been held therein and has referred to paragraph 12 and 13 of the judgment, and has submitted that in the circumstances where no compensation is payable or the applicant claims substantial sum, the amount of court fees is to be computed according to the amount of the claim, that is ad valorem court fees. The Learned Council submits that in the present case, no amount of compensation was awarded to the applicant, and the entire award was prepared in favor of the appellant herein, but the applicant had sought for a reference under section 3H(4) of the National Highway Act 1956 and thereby claimed title over the property to claim the compensation amount. The Learned Council submits that the right title interest over the property which was acquired was directly in dispute before the court, and inter se dispute between the claimant and the awardee was adjudicated by the court. The Learned Council submits that the entitlement of compensation was directly related to the right title interest of the applicant with respect to the property acquired. The Learned Counsel for the respondent, on the other hand, the Learned Counsel for the appellant, on the other hand, has submitted that the judgment passed by Himachal Pradesh High Court was arising out of appeal under section 54, and the observation made in paragraph 12 of the said judgment is apparently in favor of the appellant. After hearing the learned counsel for the parties and upon going through the impugned judgment, this court finds that the award was prepared in favor of the appellant herein, and the applicant, who is the respondent in this case, had sought for a reference, and land acquisition case number 31-12 of 2020-21 relating to award number 28 was instituted under section 3 within bracket H within bracket 4 of the National Highway Act. And the applicant claimed the entire amount of the award. The judgment further reveals that it was a specific, from page 4 of the judgment, that it was a specific case of the applicant, that he is the rightful person to get the compensation, and accordingly he prayed to declare his right title interest for the land acquired, and also prayed for a direction upon the District Land Acquisition Officer Bokaro to disburse the amount in his favor. This court finds that the issue of right title interest and right title interest with respect to the acquired property under National Highway Act was directly and substantially in issue before the court, and it was not a mere incidental issue to be gone into by the court in order to determine the apportionment of the awarded amount. Unless the right title was to be declared in favor of the applicant, no relief with respect to the compensation could be granted to the applicant. In the judgment passed by Honorable Himachal Pradesh High Court, the relevant paragraph for the present purpose would be paragraph 12 and 13. And by considering the observation made in paragraph 13 of the said judgment, this court has no doubt that in the present case where no amount of compensation was awarded in favor of the applicant, the court fees payable would be ad valorem court fees. So far as the judgment passed by Honorable Madras High Court as relied upon by the appellant is concerned, this court finds that in the said case, the court observed that it was essentially a declaration of a right to compensation and that since it was a reference made by competent authority, no court fees was payable on the reference, and section 25 read with section 52 of the Tamil Nadu Court Fees and Suit Valuation Act was under consideration. this court is of the view that where the applicant was seeking right title interest with respect to the acquired property and claiming compensation pursuant thereto, ad valorem court fees is payable. Accordingly, the objection raised by the office is sustained and the petition seeking ignoring the objection is hereby dismissed. The consequently कितना टाइम चाहिए पेमेंट करने के लिए? अगर ज़्यादा लंबा टाइम चाहिए तो कोई बात नहीं.
So 4 weeks.
ठीक. The matter is directed to be posted on 3rd of November. In the meantime, the differential court fees should be paid.
But
और तो कोई डिफेक्ट नहीं.
no.
नहीं, कोर्ट फीस के बाद ही तो डिफेक्ट है. डिफेक्ट
Stamp
निकालेगा.
reporting
बात
further.
फिर से करें.
If required, further stamp reporting be undertaken. If required, further stamp reporting be undertaken and the matter be posted before under appropriate heading on 10th of November.